Who owns creative works generated by artificial intelligence, and what does that mean for the law? Let's talk to attorney Thomas McNulty of Lando Anastasi about just that. It's the New England Take. I'm your host, AJ Kierstead, thenewenglandtake.com. To get more from the show, like and subscribe if you're checking this out on YouTube. And if you're not, please do check out our YouTube channel where we post all our videos, all our interviews, and opinion pieces over on that platform. Welcome to the show.
Thanks for having me. It's good to be here.
So I happened on LinkedIn to come across your article titled "AI-generated works should not have copyright protection," and it is this has been something I've been really curious about. I worked for 12 years at a law school as a staffer that specialized in IP, and the more and more as I saw DALL-E and ChatGPT and all these other artificial intelligence generating services, I guess is a way to phrase it, kind of go viral over and over again. It's like, this is a can of worms in the IP world, isn't it?
Yeah, it's really kind of exploded over the last 6 months or a year, and particularly over the last couple of months. And it does raise a lot of kind of concerning issues and questions in terms of intellectual property protection and the goals behind, the same.
I mean, maybe this is way jumping ahead, but the big thing, I mean, I don't even know where to begin with something like this because there's so many ways that you can dive into it. But the root that I really see as a content creator, photographer, videographer, produce shows and things like that is these tools are not organically coming up with it from their own they don't have the same brain that humans have necessarily. So I guess that's the way to phrase it. And especially with ChatGPT, and I know your article was primarily discussing DALL-E, which is image based, but essentially uses the same thing. It's using the information that it's collecting from the internet, either actively, as you're seeing with more modern text-based AI generators, or like ChatGPT and DALL-E are taking a database that it's collected from the internet over time and generating something using prompts that a user inputs into the system. I mean, isn't that inherently an intellectual property issue there when you figure that these are things that already exist elsewhere?
Well, I mean, that's one of the interesting questions is, and it's beginning to be challenged, is there an infringement by basically using somebody's intellectual property to train these things? They generally kind of scrape the net without regard to the rights of the people that hold rights in the content that's on the net, feed it in, excuse me, and use that to train them. And that's kind of one of the questions that's coming to the forefront is, whether actually taking somebody's online content and feeding it to an AI just for training purposes, not saying that they're spitting that back out, but just for training purposes, is that a form of infringement?
Because I mean, when you're talking Wikipedia, which is obviously a huge conglomeration of data, but it at least cites a source somewhere in there in theory. In
Sometimes.
theory, it's not always accurate. It's not like before where it was like you kind of hoped it was actually curated, but it's become such a beast at this point where it's impossible to really know for sure, and it doesn't even seem like DALL-E and such gives that at all.
Yeah, I mean, the interesting thing with a lot of, for example, the text-based AI is they'll spit something out that is coherent, it's grammatically correct by and large. I've seen work product that somebody asked it to produce a legal brief, and it presents coherent arguments, it presents coherent citations, but the arguments may be based on some other law. The citations may or may not actually exist, and if they do exist, they may or may not actually say what the program is telling you that they say. So I think at least at this point, it's sort of more geared towards spitting out something that's coherent than something that's technically accurate. And I think by and large they acknowledge that. The ChatGPT folks, for example, have kind of a disclaimer like, anything in here may or may not be accurate. Check it on your own.
And you're beginning to see with especially the large companies with their AI products like Bing and Google's Bard is currently in a beta mode right now. MKBHD, which is a very high up YouTuber, did a great video discussing those products and the differences between them. But you're beginning, what really stood out to me is like you're beginning to see sources begin to show up that their products, because it's their databases that they're pulling from. That, I mean, that's ultimately what a search engine is. It's a database, and it's trolling metadata from various websites. You're beginning to see that, which I'd imagine, especially as an IP attorney, you're going, okay, good. They're beginning to at least take this under consideration, because these companies are going to get sued to no end if they don't.
I mean, that may well be. The one concern I do have is, like I say, sometimes you'll get sources that are inaccurate or on occasion entirely made up. And I think the existence of sources makes people much more comfortable in trusting the content. And I don't know that we may get to that point. I mean, it's evolving rapidly, but I don't think we're at a point yet where it's safe to do so.
So let's get specifically into what your article was about, which is about Dolly primarily, which is just a
actually
it
was actually Midjourney, but I think
Midjourney, I'm sorry, yeah.
I think they're relatively the same in terms.
Yeah,
of
I think so too. There's so many of these things all popping up at the same time. It's like ChatGPT versus Bard and whatever Bing's psychotic girlfriend is that they created. If you check out some articles on that, but either way, like the AI generated images are fascinating from as someone who creates content for the internet, as a photographer, things like that. The ability to have just type a prompt into a tool like this and have an image pop out that could be used as a thumbnail for a YouTube video. It could be posted on Instagram and eventually maybe get you millions of followers on there in theory down the road if you get really good at it. It's, I mean, from an IP law perspective, like, is that a creative work that the person who typed in some text is the creator of, or is the tool?
Yeah, I mean, that's one of the interesting questions. I mean, I would argue the person who developed the software and the person, assuming it's the same person who scraped the net and trained it, and I know that's primarily happening automatically, but I would argue that those people have more creative input in terms of what human being contributed to this than the person putting in the prompts in at least most circumstances. But I think the important thing from an IP perspective right now is the Copyright Office has basically said that there has to be human creativity. It's not just enough that it be a creative work. It's got to be human creativity. And you can't actually file suit on a copyright until you get a copyright registration. So until and unless something changes, there's pretty limited avenues to try to deal with this if you're looking to get copyright on AI created material.
So I mean, this is a comparison that I'm really interested to get your take on. Is the music industry? We talked. You play bass. I play guitars. A little bit of connection there, but something that especially is more and more discussions around IP and computers creating content is music. And when you figure the tremendous amount of music that's created by something like the TR-808, which is this classic drum machine where it's pretty limited with what it can do. So basically everyone's using the same thing and they'll process it a little bit differently. But essentially it's a machine created the same music. But Roland, the creator of the 808, I believe is Roland, doesn't have any rights to the copyright of what's in there. Is that because of the way we handle music versus other forms of creative works?
Well, I think one of the key distinctions is, with the drum machine, you've only got so much kind of input or ability to alter the actual sounds of the individual drums, but it's a human being that's programming in the particular beats and the particular rhythms. And, I'm sure, they're somewhat synced to a regular, time pattern so that, the human error element is sort of worked out of it. But it's a human being that's making all of the decisions. Whereas with the Midjourney program that was at issue in this case, a human could put in, the actual author of this comic book, put in a prompt with no understanding of what would come out. It's basically done entirely through the AI intelligence, starting from a random field of static. My understanding is if you put in the same prompt tomorrow, you won't necessarily get the same set of images. If you ask it to make particular changes, you have no real control over what's going to come back. And that, at least from the Copyright Office's perspective, and probably from mine, that's kind of one of the key distinctions is, it's kind of the equivalent of asking somebody to paint a picture of whatever your prompt is. If you asked a human being to do it, it wouldn't, there'd be no serious debate that you yourself didn't own copyright because you asked them to paint a picture of something. And this is sort of the digital equivalent of it.
So I would assume then there is a line of creative input where utilization of these images in some way would in turn eventually result in something that would be copyrightable. I'm making up a word, I think. If you're something that really stood out that was recently, I'm a metalhead, so Periphery is a metal band that recently released an AI generated video, but I mean ultimately, yeah, the source video was AI generated, but then a production house took all these clips, made a music video of it, completely selected ungodly amounts of footage and said this is going to be for this section of the video, we're going to use this other section over here, and there's a level of creative input that's in turn used utilizing this footage, kind of similar like how stock videography or photography would be used. I'd imagine going to a certain level of working with the footage or photos would in turn eventually result in something that is a unique work by an artist.
Yeah, I think I agree with you there. In the particular case, the article, I don't know if we've discussed this, the article is about a person who created a comic book and the images were all AI generated. But the author actually created all the text and selected particular images and arranged them and the text, into the format they wanted. And the Copyright Office did grant copyright protection in the text and in the sort of selection and arrangement and the overall kind of compilation. But they denied copyright to the photos themselves, and so somebody could go in and take an individual image out of that book and freely reproduce it. And I think the video that you're talking about would probably be treated in a similar way. I mean, the underlying music, I'm assuming, is subject to copyright, assuming that they wrote the song themselves. It would be subject to copyright, and the sort of front to back video would probably be subject to copyright, but the individual AI created sections probably would not.
Is this kind of like a brave new world of new ways of handling like digital data because of this, especially?
I mean, it probably is. I mean, you really are, if you're trying to create something that you want to be able to prevent other people from using, you got to be careful about how you do it, how much creativity you have and how much of it is kind of automated. At least in the copyright sense. I'm not aware, full disclosure, I'm not aware of any cases to this effect, but if you used a copyrighted image as a logo to the extent that it became subject to trademark protection, I'm not aware of any prohibitions on trademark protection being applied because there's no underlying requirement for human creativity or authorship or inventorship or something like that. But in that period of time that you're trying to build up trademark rights, it would be freely copyable. And, if somebody did, you'd sort of be out of luck. So there is sort of an element you have to take to look at, what it is you will want to protect moving forward and how much you want to expose that to, these potential issues.
Do you predict this is going to be a legal gray area for just years and years, essentially, until like this becomes so mainstream where there's enough case law, essentially, because people are going to appeal all sorts of things when it comes down to it as they disagree, especially when the big companies come in with the money to support lawsuits because it's expensive to really take these cases up.
Oh, yeah, and particularly something like this that's probably going to have to go through multiple layers of appeals. I think it's going to be a gray area. I mean, the Copyright Office themselves, this decision this person had actually obtained a copyright on the comic book and then publicized that they had been the first one to obtain copyright on AI generated stuff. I don't think the Copyright Office would have known otherwise. Which don't lie to the Copyright Office. That's not the answer I'm giving, but So the Copyright Office kind of dealt with it, but at the same time, they're putting out a solicitation for public comment on how to handle this sort of thing. There's been talk at the congressional senatorial level about trying to find some way to regulate IP issues as it relates to AI generated things. There's certainly a lot of gray area as to how much human creativity, what's the threshold where that becomes enough that they can get a copyright in it. And then, on the worldwide level, the vast majority of the world has kind of taken that has addressed it anyways, has taken the same position as the United States. But some countries are considering an alternative approach. And I think the big one right now is the United Kingdom, at least for copyright, is allowing copyright on AI generated material, and they're giving the rights to the person that entered the prompts. And that's a policy based decision. They want to promote the sort of growth and spread of AI technology coming out of the United Kingdom. So I think, and quite frankly, that's one of the reasons I don't think the Copyright Office or the Trademark Office or Patent Office rather, or the courts should themselves be altering things. I think this is very, very policy heavy kind of decision to make, and it should really be made, by the legislature with the full ability to investigate and hold hearings and solicit public comment, that sort of thing.
Are we kind of in a similar state like when the internet first started becoming mainstream? Like it's what it really seems like. It's
yeah, very much so.
Yeah, I mean, who owns the code? I mean, is it the person who keeps typing in the same HTML garbage like back in the 90s that we all had to do, or is it a matter of the person that types in prompts?
Yeah, I mean, we're sort of getting into the same thing, and I was actually just reading an article today of concerns among publishers of when the internet first came out and it sort of became generally accepted that if it's online, it's free. Their businesses took a beating, and there's some talk about them trying to really band together and really, put a lockdown on scraping the internet and using this information because they're concerned that the same thing will happen to a far greater extent.
Yeah, I mean, there's an inherent problem. The fact that these tools are just straight up scraping data, especially with ChatGPT and such. Like that. I'm shocked there hasn't been more red flags raised about the way these tools are using it.
Yeah, I agree with you. The other thing that's sort of an interesting question is if one of these things spits something out that's pretty much a copy of something that was fed into it, A, is it copyright infringement? And if it is, B, who's liable? The person who put in the prompts, the AI owner, I don't know.
The AI. It's like, what's a brain? Oh God, now we're getting into ethics. Help us all.
Yeah. Well, you're getting into ethics, but you're also getting into ChatGPT as a, I don't know, entity of whatever sort, has no money.
Yeah. Yeah. Yeah, and who owns these codes, and oh God, Microsoft owns way too much of these sort of things, and it's gonna be the Windows versus Mac ecosystem again here in another 10 or 20 years. But I guess we'll have to wait and see, and we'll definitely be looking to IP firms like Lando and Anastasi for their expertise in these. Thank you so much for joining me today.
I really enjoyed this. Thank you.
Attorney Thomas McNulty over at Lando and Anastasi, LAlaw.com to get more from them. They are based out of Boston primarily, and I've had their founding partner, Peter Lando, on the show before, who's great, so I highly suggest you check out that. They're doing some groundbreaking work over there. You're watching The New England Take. I'm your host, AJ Kierstead, thenewenglandtake.com. Like and subscribe if you're checking this out on YouTube. Follow us on social media, and be sure to also check out our podcast feed. I have abandoned that for a while, but I promise I'll start uploading all the episodes there as podcasts, so you can follow us on all those platforms. Talk to you in the next episode.